Good evening, everyone. Please note that the meeting is being live streamed. In the event of any technical difficulties, the meeting will be recorded and uploaded after it concludes, making it available for viewing the following day. Please switch off your mobile phones to silent. Welcome to this meeting of the Overview and Scrutiny Committee. I am Councillor Grace Watson, the Chair of the Committee. Can I ask members to please introduce themselves, starting from my left with Councillor Brooks.
Good evening, Councillor Sue Brooke.
Councillor Nick Harvey.
Good evening, Councillor David Thomas.
Good evening, Councillor Matt Cortez.
Good evening, Councillor Lorraine Larman.
Good evening, Councillor Diana Jones.
Good evening, Councillor Kate Knott.
Good evening, Chair. Councillor Sharon Ainsley.
Thank you. I'd also like to welcome our independent persons, Dale Phillipson and Jenny Beaumont, to Chamber. Thank you for attending tonight, and if you'd like to introduce yourselves as well so we know who's who, even though it's obvious.
Thank you, Chair. Dale Phillipson, independent person on the Overview and Scrutiny Committee.
Thank you, Chair, for your welcome. My name's Jenny Beaumont and I'm an independent person to this committee. Thank you.
Thank you. And I'd also ask Councillor Copsey to introduce yourself.
Good evening, Councillor Tim Copsey, Cabinet Member for Strategic Planning. Thank you.
All right. The first item on the agenda is item 1, apologies. Members, we've received some apologies, but if Holly can confirm all.
Received apologies from Councillor Sage, Councillor Bowker and Councillor Bredding.
Are there any interest to declare? No interest? Item 3, minutes. Members, the minutes of the meeting held on the 2nd of July 2025 have been circulated. Are the minutes agreed? Councillor Jones.
Thank you, Chair. With regard to the minutes on page 2, towards the lower half of the page, in response to a member query relating to the mechanisms in place to monitor and sustain improvement, officers advised that a suite of key performance indicators was being developed and would be reported both to Cabinet and the Overview and Scrutiny Committee. These would be used to hold the department to account. The KPIs were expected to stand up to external scrutiny. As the member making the query, I know that I also asked a further question regarding what would happen if officers did not show any improvement. What scrutiny, what accountability would there be? So I would like to see that the minutes reflect that aspect of my questioning, please. Thank you.
So the actual minute, and I did refer back to the live stream of this, it does actually address the fact that persistent underperformance would be addressed through management policies, and that was made very, very, very sort of clear and is reflected accurately in the minutes. As members will appreciate, the purpose of a set of minutes is not to give a verbatim account of meetings and to reflect all questions that are asked at meetings. It's to actually reflect the decisions that are made and also any recommendations that are made, and to give a flavour of the actual debate. There is a live stream there for members of the public to be able to watch if they do want to kind of, a bit of a script for the meeting. But that is an accurate reflection, and the response is recorded in the minute.
Councillor Thomas.
Thank you, Chair. I agree with Councillor Jones. So I think that should be in the minutes. It's only online for a certain time. It's not forever and a day. Also, it begs the question is, who decides what's going in the minutes and what isn't? What we say. So I think that's such an important thing, it should be in the minutes. Thank you.
Right, I've just been informed it is online permanently, but I think there is a very valid comment you've made here, and it's something that we need to discuss further on with the officers to get the update that you require. If we can get that sorted, Sonia, I'd appreciate that.
I will sort of raise this outside the meeting because, you know, I think there was a slight sort of misfit here, so we take that on offline, please, members. Okay.
Are you happy with that, Councillor Jones?
Yes, thank you, Chair.
Thank you. Right, item 4. It's a report on houses in multiple occupation, HMOs in Castle Point. Members, we have before us a report from the Assistant Director Development Services which sets out details relating to the number of homes of multiple occupation located within Castle Point and the impact on the local amenity and people's well-being. Councillor Corpsey, as portfolio holder for strategic planning, please introduce the report.
Thank you, Chair. Good evening, councillors. Thank you for the opportunity to speak today as you begin your scrutiny of the report on houses in multiple occupation, HMOs, within Castle Point. The item was brought before Cabinet last month in response to concerns raised around the presence and regulation of houses in multiple occupation, commonly referred to as HMOs, within Castle Point. Following being presented to Cabinet on 16th September, Cabinet resolved to refer the matter to this committee for further examination and debate. The report before you at item 4 Appendix A is the same as that was being presented to Cabinet, and it provides a comprehensive overview of HMOs, including the legal definitions and thresholds under the Housing Act 2004 for building control, environmental health and planning, the licensing requirements for large HMOs, 5 or more, the planning and building regulations that apply to HMOs, and the mechanisms available to local authorities to manage HMOs, such as optional licensing schemes and Article 4 directions. It also sets out the current context within Castle Point. At present, there are 16 licensed HMOs accommodating 91 individuals. When cross-referencing planning records, council tax data, electrical services and census information, it is estimated that there may be around 42 HMOs in total across the borough. That equates to just 0.11% of our housing stock, one of the lowest rates in Greater Essex. Importantly, the report finds no evidence that HMOs are currently causing harm to the local amenity or well-being of our residents. There is no identified correlation between HMOs and crime or antisocial behaviour. And no concerns have been raised by our housing or community safety teams, nor by Essex Police. However, the report does outline the options available to the council. These include introducing an optional licensing scheme for smaller HMOs, implementing an Article 4 direction to remove permitted development rights, or pursuing both measures in tandem. Each of these options carries legal, financial and resource implications, and crucially would require robust evidence of harm to justify their introduction. The Cabinet felt that given the complexity of the issue, it was appropriate for this committee to undertake further scrutiny. I look forward to hearing your views and to supporting your deliberations in any way that I can. Thank you.
Thank you, Councillor Copsey. Do members have any questions? Councillor Knott.
Thank you, Chair. With regards to 8.14, does the possibility of compensation only apply if someone has started building works prior to, if we were to bring in section 4?
Who's answering?
Sorry, please bear with me while I just find that. Was it 8:14 you referenced? Thank you. So there are two types of Article 4 direction. There is an immediate direction and a delayed direction. The immediate direction is where costs are payable. A delayed direction is where we give notice to say that, for instance, in 12 months' time, we will be introducing this. If it's the 12 months one, there are no financial compensation payable because it's not immediate. With the immediate one, it doesn't just apply to works that have already started or are about to start. It can apply to anyone who, within the next 12-month period, decides that they want to apply for planning permission to convert into an HMO, or who feels that potentially it might be a business or someone who's purchased a property with the intention of converting it into an HMO, they could apply for costs against the council.
Can I come back on that, Chair? Thank you. So would we have to see like robust evidence for that? Otherwise anybody could turn around and say that was my plan and make money from that to get compensation. I'm just thinking, how do we actually evidence that?
They would need, sorry, through you, Chair. They would need to evidence that there's been a financial loss. They couldn't just say there's been a financial loss as a result and expect us to pay out.
Thank you. Councillor Cortez.
Thank you, Chair. With regards to the optional or the additional licensing option that we can take, do we get to write our own spec for that, or is it as stated by the government? Thank you.
Jeanette?
With the optional licensing, we don't get to write the spec. It's basically the same requirements as for the larger HMOs, just applied to smaller ones that wouldn't usually require licensing, because the licensing under the environmental health legislation covers those with 5 or more people, and the optional licensing applies the same rules to smaller HMOs, so those with less than 5 people in them.
Thank you. Can I do a follow-up part to that, please, Chair?
Yes.
Thank you, Chair. Is there no way that we could then incorporate something that bans HMOs being let to a business, a company, an organisation, rather than to, for example, 5 separate individuals all under a separate tenancy?
No, there's nothing in the legislation that would allow us to do that.
Thank you.
Thank you. Councillor Ainsley.
Thank you, Chair. So I've done a bit of research into other councils which have invoked Article 4. Wigan Council. So Wigan Council introduced a borough-wide Article 4 direction to address concerns about poorly managed HMOs. Their direction removes permitted development rights for C3 to C4 conversions, requiring planning permission for all such changes. It goes on to say, which is kind of in conflict from what we've just discussed. Important notes: Article 4 directions do not apply retrospectively. Existing HMOs created before the direction came into force are not affected. LPAs must follow a formal process, including public consultation, before implementing an Article 4 direction. It goes on to say the direction can be immediate or non-immediate, delayed to allow for consultation and notice.
Thank you, Councillor Ainsley. Stephen Garner.
Thank you, Chair. That is correct. I'm sorry, which bit were you saying was slightly in contradiction?
About not applying to existing HMOs.
That is correct. It doesn't apply to existing HMOs. So existing HMOs that already exist, this wouldn't apply retrospectively.
Thank you. Councillor Cortez.
Thank you again. It was just more of a point on the maps that we're shown regarding the location of our current HMOs and crime figures and antisocial behaviour. My colleague, Councillor Copsey, said that there's no correlation. Maybe it's because the map is quite small, but there looks like there's quite an awful lot of correlation between crime and where the HMOs are. Is that more just the fact that the HMOs are in places where there was crime previously?
It's partly down to the fact that because we've had to make the HMO targets quite big, because some of them aren't located, like the ones that are on the environmental health licence register were published online. However, the other addresses have been obtained via a variety of means through electoral services, council tax, and as a result, they're not publicly available. So we've made the sort of the blue and purple circles for those quite big to sort of mask the specific locations. You make a very good point about the fact that are they located in areas that would otherwise see that. My view on that is that generally, yes, you would typically expect more antisocial behaviour, more crime to take place around town centres, sort of hotspots, so places like tar pots along sort of main roads and things like that, and that is typically where we see them. When you looked at it's also as a part of the size of the dots and the heat map that's been provided, when you look down into the data, they do seem to be further away, but I take your point.
Sorry, through you, Chair. Through you, Chair. Thank you. It was just to confirm, yeah, that there isn't a correlation between the location of the HMOs and the crime data. Don't get me wrong, there are one or two incidents that happen within properties as always, but nothing that correlates to, if you like, defining a nuisance or saying a nuisance exists.
I thought that was the case, but I just wanted to check.
Of
Thanks.
course. Thank you.
Yeah, I've got it. Councillor Edwards.
If I can just pick up on this, we're throwing around the phrase no correlation. I'd like to understand how the analysis was done. Is this analysis done on a borough-wide basis, or is it done on correlation between the crime hotspots and most proximate HMOs? And does it vary by type of crime? Because, for example, organised crime, people fly to do it. All right? Muggings, you might not want to do on your doorstep because people will recognise you. So different types of crime have different proximity to the location that the criminal lives at. And this, I don't see any data. What I see is a heat map, and the heat map's overlaid, as you said, with non-precise locations. So is it a crime hotspot has been analysed relative to the proximity of HMOs, or have we looked at the map and where the spots are?
Through you, Chair. So we've got the general crime map, which is the fourth map in it. That is all crime within the borough, and is just a heat map that's been looked at in relation to the locations of the HMOs. The fifth map that's included in the appendices is specifically isolating antisocial behaviour as a result. We haven't isolated out all the different crime types. However, we have spoken to the police, and they've not said that they've got any information or evidence that supports that HMOs are resulting in additional antisocial behaviour or other types of crime in those areas.
And through you, Chair, so can you put a number on the correlation then?
Sorry, through you, Chair. Just in answer to your previous question, in relation to the types of incidents that are happening, if you're looking for individuals that are causing nuisance, they will be dealt with using antisocial behaviour legislation, policing legislation, even though they may live in a HMO or may live elsewhere. So they're dealt with separately. When you're looking at the Article 4 direction and how that whole process works, that's to do with nuisance that may be affecting, if you like, the property. So you're talking about two separate things, and it's important just to draw that distinction, because what people do outside of the homes is one thing, dealt with one way. What people do within a HMO and the rules and legislations that kick in is something else. Thank you.
So,
Councillor Cortez.
Sorry, can I just finish the? I
Yes,
didn't
of course,
get
I
an answer.
apologise.
That's
Yes.
all right. I didn't get an answer to the question. What is the correlation?
There isn't a specific number assigned to that.
Right, okay, because normally when you do a correlation analysis, you do something between 0 and 1. So my question is, have we actually got a correlation analysis, or are we looking at the proximity of dots to a map?
Through you, Chair, it's been done on the proximity of the HMOs to the heat map.
Thank you.
Councillor Cortez.
Sorry, I should know that. Just to clarify, I was having a conversation with a councillor that's not a member of this committee. I'm right in thinking that we are classing HMOs as purely residential. We're not including anything that would be assisted living. We're not including children's homes. We are looking them as traditional HMOs for this policy.
Through you, Chair. So that's where it starts to muddy the waters. Unfortunately, in this instance, we've not been looking at children's care homes because they are separate. However, there are some types, and it depends on the level of assisted living, as to whether it comes into being a care facility or whether it's people who, because you could have 3, 4, 5 individuals living together who require some assistance, but they don't. It doesn't tip into the care facility. In this instance, though, I believe from the data, there's only 2 of those such sort of assisted facilities that have been included in that up to 42 HMOs. But going back to your original question, no children's homes are included in that, but only 2 assisted livings are.
Councillor Cortez, you wish to come back?
Thank you, Stephen. I take it then we haven't done something silly and published addresses where there's vulnerable people out of the 2 living, where there's people like for example, women fleeing domestic violence or something like that. We haven't published their addresses, have we?
The only addresses that have been published are ones that are legally required to be published on an environmental health HMO licence register. They're already on our website, and the other ones are from the planning portal, which is all publicly available information. The information relating that I've looked at for electoral services, council tax and the like, that's not been published because, as you say, sensitive information.
Councillor Ainsley.
Thank you. I'm looking at the map and there's a couple in my ward, but I can't see them on the list of HMOs that's actually published prior to the map. Where is the one near Jotman's Hole? And it looks like there's one in Brook Road as well, but I can't see that on this list. I mention it because there's an awful lot of trouble in Brook Road. So we've got 2 marked on the map in St Mary's, but they're not on the actual list 5.2.
Through you, Chair. So the ones that are published are the ones that either require a licence or we have a record of on the planning system, on the public planning portal. All other HMOs that are included on the maps are ones that we've obtained information from through electoral services or council tax records, and that's why specific addresses wouldn't appear. If there's additional HMOs that members are aware of that do not feature on the map, that may be, but I've only gone off the information that's available to us because we don't have to have everyone report where HMOs are if they don't require a licence or planning permission. So it's particularly with the smaller ones, we may not know where they are.
Councillor Jones.
Thank you, Chair. I would just like to follow on the line of questioning from Councillor Edwards with regard to the recorded crime and the recorded antisocial behaviour. In terms of recorded crime, is it just any crime that's been recorded?
Yes.
Thank you, through you, Chair. So the crime that was any crime was taken from the UK policing website. So that does include literally any crime that they report on. So everything from antisocial behaviour to theft and sort of sexual assaults, aggravated, and all of that. It covers everything.
Right, thank you. If I could just follow up, Chair. Thank you. So there could have been reports, or there could have been incidences of antisocial behaviour that wasn't actually reported to the police, which would not have been covered by your heat map.
Thank you, Chair. Yes, this is only on reported crime because that's the only evidence and data we have available to us.
Could I follow up with another question, please? Thank you, Chair. Would it not have been a better or another way of finding correlation between crime, which would be to see if any residents, known residents within those HMOs have been convicted of any crime?
Thank you. Through you, Chair. It's always difficult when the council is trying to manage community safety in terms of going fishing for information and the legislation that sits behind fishing for legislation and what that allows us to do and not do. So in terms of that information, should anything come to light in relation to bad behaviour from a person within a property, the action will always focus on them. Does it have a bearing on how the HMO functions and operates? No, it wouldn't. The HMO functions and operates exactly as it would. In terms of how my home functions and operates, it operates as a home. But if I, as an individual within that home, cause nuisance and antisocial behaviour, I can expect to receive specific action on that. So in terms of whether it would be useful to whether a HMO should continue to operate based on the occupants within, no. Essentially, you would go after the individual as opposed to going after the HMO. That would never be how that process works. Thank you.
Thank you. Councillor Thomas.
Thank you, Chair. My question is about the standard of living in HMOs, or the standard of living that they can have. So, for example, say we have a 5-room HMO. I hope there are rules in place and checks in place. How do we know, like, each room only has one person in it, or whole families crammed into each HMO? Are there checks in place, and what can be done to prevent this sort of overcrowding?
So there's a set of standards that have to be adhered to, which I'll defer to Jeanette in a second to answer. When it comes to checking how many occupants are in a room, because it is picked up in the report that that's a frequent pitfall that HMO operators fall foul of, it's based on people and not bedrooms. So it could be very easy to let a room which has a double bed in it to a couple, and then suddenly that tips you over a threshold and you suddenly require permission. As far as planning is concerned, if we receive complaints from people, we will go out and check. We have done so on some HMOs, and it can become a little bit invasive. We did one where the HMO operator was saying, no, there's only 5 people here. It doesn't require planning permission. But when we started checking belongings, we were finding multiple people's sets of clothes in a bedroom, so it suggested that couples were living in each room. So if that's from a planning perspective, if I can hand over to Jeanette for the sort of living standards.
From an environmental health perspective, there is a set of county-wide amenity standards which apply to houses in multiple occupation. And though the ones that require licensing, the licence is not an indefinite licence, so they will need to renew the licence at the end of the licence period. So an inspection will be carried out at that stage, and the authority is within their right to do a more frequent inspection if they choose to. That's part of the conditions of the licence. So if there is any hint that a particular HMO may be being badly managed, or there are sort of any indications of problems, neighbour complaints, that type of thing, then we are within our rights to go do a further inspection between the period of the licence being granted and renewal.
Thank you. Councillor Cortez.
Thank you, Chair. My question is, I've got a different question, but my first one is following up from what Councillor Thomas just asked. Do we have the facility to look at how these landlords are acting, not only in our area, but is there a register of how they've acted with other HMOs, so that we don't end up with a rogue landlord setting up an HMO in Castle Point that has already performed badly, for example, in Basildon or even outside of Essex? And secondly, to follow that on, do we have the immediate ability to withdraw that licence and ban the person from running an HMO? They're very lucrative, but they do need management. So do we have that ability, or do we have to wait for the licence to end?
No, we don't have to wait for the licence to end. If there is a hint that a HMO is being poorly managed, there is a set of management regulations which we can enforce on, and people can be banned from running a HMO, and the local authority can either take over the management of the HMO or appoint somebody to do that instead of that person. And there is effectively a rogue landlords register, so that information is available, and all local authorities have got access to that.
Did you want to come back?
Can I ask my actual question that I was going to ask rather than the follow-up? Yeah. It's going to be more for Stephen. With regards to the planning permission with them, what do we look at with regards to parking availability? How much of that do we take into account? And the size of the amenities? My background is financial services for a lender that actually specialised in HMO. So I know what our criteria was to get the mortgage on an HMO. From a planning point of view, have we got minimum sizes for rooms, for example? Do we insist on there being a communal room? Do we insist on X amount of parking or a set number of bathrooms per residence?
So under planning, there aren't set sort of room sizes, shared facilities, although they need to have a certain amount of shared facilities to even qualify as an HMO in the first place. So if they all came in, they were all self-contained units, that's not an HMO, that's flat. So there is that. When it comes to amenity space and things like parking, typically these are coming from being normal family dwelling houses and the conversion is happening. If they're not changing the actual sort of they're not increasing the size of the building, then the likelihood is that the amenity space that's already available, it's not changing, and you could potentially have, I don't know, you may have 6 occupants living in a house, you could potentially have a family with 6 people living in it. As far as plan is concerned, it wouldn't really change the situation. So there may not be a sort of a change there. With parking, we would be looking at the adopted parking standards for HMOs. They do, similar to residential dwellings, there's flexibility in how they're applied, but they would be looking at sort of like the parking needs of the dwelling.
Right. Independent person, Jenny Beaumont. Thank you.
In terms of the options available to the council under this matter, you've listed 4 options towards the end of the report there. I just want to ask a question really about, clearly those are the things that you've identified there are things that are currently already in place, that you currently use and administer. So I'm just wondering, how frequently are those currently used across the borough? If you looked at all those together, would there be any, I hesitate to use the word correlation, between these matters and the residences that you have identified? And to really just sort of understand the process of how that happens, that decision making.
Stephen?
Are you referring to the options in 9.1 of the report?
I think it's, I think you've listed the powers under 13.3.
Sorry.
So you've got your civil injunction, your closure notice, closure order, and your community protection warning notice.
I'll hand over to my colleague Damien, who would be better placed to answer that one.
Thank you.
Thank you. Through you, Chair. Sorry, can I just, if you could just clarify the question again, just so I'm sure about the answer. Thank you.
So the question I'm really asking is, because we're having this debate around this, and also because you have identified options which powers that are typically available to the council. What I'm interested to know is there any connection in that list between that and the matter of discussion, or is that a general list that is currently used for the council to exercise its powers, and what's the process for that?
So, through you, Chair, just to confirm, that's a list that can apply to anyone. So what this list is attempting to do, these are powers available under the Antisocial Behaviour Crime and Policing Act. In the worst case event that occupants within a HMO or a property start to cause nuisance, these are some of the powers that we can use. So if I just give a very quick example, if a particular occupant of a particular room within a HMO is causing nuisance, these are some of the powers that are available to the council through community safety to basically resolve that nuisance. Now, it can be, for example, as simple as using certain notices to tackle certain types of behaviour. It can also extend out to some sort of injunction against the individual, or in extreme cases, and I do mean extreme cases, those powers can be used to shut down a particular room, or again, in extreme cases, the entire building. And it really is to tackle, and I must stress this, antisocial behaviour.
Yes.
Thank you. I suppose what I'm really trying to get at is, are they sufficiently robust at the moment, those processes? And in your opinion, when you were writing this report, did you take that into consideration when you were looking at the options that were being offered up?
Thank you. Through you, Chair. Are the powers robust? Absolutely. The powers are the powers that local authorities up and down the country use to tackle antisocial behaviour. From a council perspective, if it starts to become more serious than that, then it becomes a policing matter, and then you're talking about different types of offences, different types of penalties. What I can say, if you were to say to me, have we used any of these powers in relation to existing HMOs? No, we haven't, to the best of my knowledge. But they are simply powers there to help tackle antisocial behaviour, whether it's an HMO or a private dwelling or a council property. These are powers that are focused on the individuals. Thank you.
Thank you. Councillor Edwards.
Just looking at the options that are in front of us, it doesn't make much sense to me to implement an optional scheme without the wider capability of an Article 4 direction, because as it notes, we would separate the two forms of control that we've got, planning and environmental health. But could I have the officer's opinion on whether staging that would be an option? Because I think if we brought in an optional scheme, it would grant us more visibility into the HMOs in the borough, and then we could take a view, possibly with a more robust evidence base, on whether we then go for a full Article 4.
It could be an option to do one and then revisit the other at a future date. So in this instance, you're talking about potentially introducing optional licensing to get better visibility. That could possibly happen. Just would you mind clarifying, because I think you said there was a difference between planning and environmental or the licensing legislation. Would you mind just clarifying that point for me?
Well, I believe it's a point made in the report, unless I misunderstood. But the point that the powers that are available to us are separated by the optional process versus the Article 4 direction. One is a set of planning rules and one's a set of environmental health rules, so you don't have your full toolkit available unless you've got both in place.
Thank you. I understand what you're saying now. Yes, that is true. They're both different under different acts and different bits of legislation. They are tools available to us. Frustratingly, these things never align. As you'll notice in the report, the threshold for what defines a HMO under environmental health legislation versus planning legislation is different, just to frustrate the process. But no, I understand.
Just to wrap that up, and I'm happy to take input from you, Jeanette. There's no real barrier to us separating those, but recommending to Cabinet that we keep it as a flow of work that we're looking to.
No, there's no problem with doing the two things separately. Optional licensing could be introduced without an Article 4 direction. All it would do is apply the same requirements to for a license to the smaller HMOs. So we would just sort of be more clear as to where they are. The thing I would probably stress is that the amenity standards and things like fire and the safety issues apply to all rented accommodation, regardless of whether they're HMOs or not. So introducing the optional licensing scheme is really just about the application process and the publication of the address on the website. It doesn't introduce the only additional requirement is the requirement to be licensed. It doesn't change things like the amenity standards, which are on our website, which relate to the size of rooms, fire safety, that type of thing. That all applies in all private rented accommodation.
Thank you, that's helpful. So my thinking is then that we've got, so just to clarify, we basically must apply, all of the rented rules apply, as you've just said. And from a planning perspective, there's no neighbourhood consultation, no actual, it's purely with people who have an interest in the property and planning concerns. So we don't actually, by bringing these in, gain direct control over the numbers of HMOs or anything realistically. So what we are really discussing is more visibility and the ability to actually stop HMOs full stop with an Article 4 direction. That's taking it to the full extent of what we can do.
Through you, Chair. An Article 4 direction wouldn't stop HMOs. It just requires the planning permission to be applied for, and then it would be considered against material planning considerations. If there are no material objections, then we have no choice but to grant planning permission. It just adds an extra step to the process. But I take your point on the greater visibility of where they are located and how many there are.
Thank you for that precision in the answer.
Thank you. Councillor Ainsley.
Thank you, Chair. We talked an awful lot about antisocial behaviour and, effect on the neighbourhood. My concern is more surrounding the actual occupants themselves and their safety. Unfortunately, the world that we live in these days, there's human trafficking, there is exploitation, coercive control. I've come up with a few recommendations that I think that we should put to Cabinet that we should also apply when looking at HMOs, because I just think that it'd be so easy for people to be exploited in this way. I think we really need to look at safeguarding issues as well.
I agree. If you've got recommendations, please bring them forward. Stephen? Damien?
Thank you. Through you, Chair. So in terms of safeguarding and the occupants within them, I think we have to remember that where a managing agent may be managing a HMO poorly, action would be taken against the managing agent, not necessarily the HMO itself. It wouldn't stop the HMO from operating, if you like. It would try and correct the behaviour. In terms of those that are at risk within the HMO and safeguarding process is triggered, again, it focuses on the individual as opposed to the building. If we're thinking that we can introduce some sort of antisocial behaviour conditions that stops the HMO from running, no, because once those powers expire and the individual or the instances are dealt with and the safeguarding is put in place, the operation of the building can still continue as a HMO. If I can pass across to Mr. Garner, just in relation to conditions that could apply to the building itself, I'll leave that for Mr. Garner to advise. Thank you.
So if there were an Article 4 direction, we could place certain conditions on properties, but they need to meet the 6 conditions tests in order to be enacted. Depending on what the proposals were, would depend on whether they could be a planning condition or not. But without hearing them, I wouldn't be able to comment.
Yes, you may.
I wasn't really referring to the building or antisocial behaviour. As I said, I'm really concerned about the abuse of the occupants because they go unseen. So I would like to see multi-agency collaboration. The police, the NHS, NGOs, safeguarding boards, adult services, to go in and inspect these and find out if these people are being exploited.
Damien?
Thank you, Chair. Through you. In terms of who the occupants are, who the managing agents may choose to let their properties to, the council wouldn't receive information on that. In most instances, there are some exceptions where the council may receive some information about occupants within dwellings, within HMOs. Where there is any safeguarding risks concern, of course, a multi-agency approach will be taken. That'll be through community safety, that'll be through some of the safeguarding channels that I've got, and that will pull together a whole range of agencies to look at individuals, processes, dangers, risks. So does that process exist? Yes, it does. Can we say that it will get, we get foreknowledge of who the occupants are so that we can do that early doors? Not to that extent. Not to that extent. That would come out as the HMO begins to operate, and only if it applies to the certain managing agents that we get that information from. Thank you.
Thank you. Councillor Knott.
Thank you, Chair.
Sorry, Councillor, if I could just stop you there. Sorry, Stephen. Ian. Sorry, Ian.
Thank you, Chair. Just to say, members, totally understand the concerns that you're raising. That's a really good point about the occupants of the of any HMO. We have to treat these people who live in the HMOs exactly the same way we would anybody else who's moving into the borough or setting up a household or a home within the borough. Equality is absolutely essential, and we can't make assumptions that simply because it's an HMO, these are people who could be at risk or the people who could be committing antisocial behaviour. There are instances, unfortunately, within HMOs, and there are instances, unfortunately, within other forms of accommodation as well. So I'd just like to say that we have to treat these people in these facilities in exactly the same way we would elsewhere. But your concerns are noted, and if, as Damien has said, if there are safeguarding concerns, then a multi-agency approach then swings into action. We will deal with it that way. Thank you.
Thank you, Ian. Councillor Knott.
Thank you, Chair. Could I just ask what criteria is used to ascertain what a fit and proper person is?
Janice, would you take that?
With the fit and proper person, there are certain checks that are carried out under the legislation, and it's things like sort of the criminal record and that type of issue with regard to the person running it, and certain searches, legal searches, are done on the point of application. When the application is received, obviously they fill in all their details, and we search to confirm that those details are correct and verified.
Thank you.
Thank you. Councillor Larman.
Thank you, Chair. I've got sort of two questions. Number one, will everyone be on the electoral roll, or is that would that be a way of checking? I know I've read somewhere in the report about that it's not a way of doing a head count, because obviously that's all down on people actually putting their own name in. But, would that be a part of the criteria for the HMOs?
Through you, Chair. So as part of this exercise, I've spoken with colleagues in electoral services, and part of the problem with the data they have on properties that may be HMOs is you don't have to tell them that it's an HMO. The ones that they have been told are HMOs are where normally the property owner or management, whoever's managing it, has reported it to electoral services that it is an HMO, and so there may be different people living there, and they then write out and see who they get register. Obviously, as part of the electoral register, it's not a requirement to register, and there may also be people that are ineligible to register to vote. And so it's, whilst I've used it as an indicator to inform this report on the locations, it's not been a way of sort of coming up with a head count because of those sort of we can't rely on the data that it provides to 100% accurately prove the number of occupants.
Thank you.
Thank you. Second part of my question. The Cabinet have asked us to look at it as a committee in a bit more depth. I'm wondering if there's a reason behind it. Are we expecting, with the housing shortage as we've got, are people expecting more people to put in for licences, or are we expecting more of an influx of this type of housing in the borough?
Stephen?
Thank you, Chair. So HMOs, there's no denying they serve a form of accommodation that is needed across the country. They provide homes for people who can't afford to move out on their own. I know someone who lives in an HMO. They moved into the area for work. They've moved into an HMO because they couldn't afford to rent somewhere on their own, and they couldn't afford to buy somewhere. So it provides a cheaper form of accommodation for those who need it. Whether it's completely possible that there may be an increase in demand for them, given the sort of cost of housing. I haven't got any information on that to hand, but it's not unreasonable to see that it's a type of accommodation that may see further need.
Thank you. Councillor Cortez.
Thank you again, Chair. Following on from that, I agree. There's various reasons why HMOs work and why they're needed for both the tenant and obviously the landlord as well. How do we cover ourselves with regards to more shorter term lets, as in something like an Airbnb? You've got 4 friends, 5 friends want to rent a house for a week. Obviously, that wouldn't come as an HMO, but it's still technically an HMO.
Thank you, Chair. So it all comes down to whether it's occupied as a single family unit or single family dwelling house. It may well be with a group, your example, a group of 4 or 5 friends, they rent a house for a week. Chances are they may occupy it like a family might. They eat their meals together, they cook, they share the living room and facilities like that, and then they leave again at the end of the week, and it's not really much different in character to a normal residential house, except that there's different people there. Where we have under planning taken action against typically Airbnb properties is where there's a significant change in use that is beyond what you would expect for a normal residential property. There was one we took action against last week, quite a large property, and there was sort of 20 to 25 people renting it out. Now, that and coming and going all the time, the noise, the waste, it's quite a bit different than what you would typically expect from a single family dwelling house. So there is a sort of a bit of a sliding scale on that, but there is a... Sorry, have I answered your question, or is there something? Yeah, okay, thank you.
Thank you. Councillor Thomas.
Thank you, Chair. I want to go back to potential financial implications that was mentioned at the very beginning of the brief, going into immediate section 4, where they have the potential of compensation claims against the council. So I've a few questions on this. Is there a cap on costs that can be claimed from Castle Point Council should a claim come through? Does the council expect any claims? And does the council know how many HMOs were established in the last 12 months to give us an indication of what might come in the next 12 months?
Thank you.
Thank you. So there isn't a cap on cost. As answered earlier, they'd have to be able to justify why they've gone to the cost. They can't just come to us and say, we think you owe us money. But there isn't ultimately a cap, so it is, in theory, unlimited. It wouldn't be, obviously, if we do a 12-month notice period and a non-immediate Article 4 direction, there aren't costs unless people legally challenge us on the process. If it was to be an immediate one, there would be costs, and I wouldn't be surprised to have costs claims against the council, because if businesses are making investment decisions based on, I'm going to purchase a property, I'm then going to convert it into an HMO, and suddenly you put a barrier in the way to that, or there are costs applicable if we put additional conditions on a planning application, they may then apply there. So I do think it's possible that costs could happen. Insofar as how many, if please bear with me, looking at the table which is at 5.3 of the report, that shows the planning applications we've received for HMOs in the borough. And you can see from that in the last, since 2024, we've had 20 Carlton Drive, 51 Thundersley Park Road to come in twice for 2 different amounts, 15 Hernham Road and 93 High Road. So in effect, we've had 5 different properties since the start of 2024 for planning permission. And if you look at the problem with, I don't know off the top of my head with licensing, unless Jeanette or Simon can assist me, because where they renew a license, I presume it renews it might be a renewal rather than a brand new HMO. But are you able to help on that? Yeah, sorry.
May I ask a supplementary question while it's been looked up then, if it doesn't go up yet? So could you explain what costs they actually have to prove as loss, as a general idea, please?
So it could be as simple as they've had to submit a planning application, so you've got all their architect's fees, application fees and things like that. Could subsequently then extend to, if it went to appeal, any appeal costs, any legal costs that they have. Beyond that, I'm not they're the immediate costs I can think of, but there may be others that may apply.
I have to come back on that again because can I just quickly? You said architect's fees. The architect's fees would have been there anyway. We're not saying we're turning it down on architecture, because the plans are the plans that the architect has drawn up. So surely they couldn't claim the whole architectural fees, which is normally £2,000 to £3,000 per building anyway, I would assume.
Ian?
Thank you, Chair. Can I suggest that this is a really grey area because there isn't much research on this, but can I suggest that we go away and do some research and circulate a note separately, if that's acceptable, Chair, to the committee on that particular issue, if that's okay?
It does bring up an issue then, if we've got to take this away, that potentially we couldn't make a decision tonight on whether to wait 12 months or want to bring it in immediately. That would take it away from us. So how quick could this be turned around?
Yeah, I mean, we could turn it around in a week. I will pick up on the point that you've raised about, well, they'd have architects' fees anyway. They wouldn't necessarily, because at the moment, if you buy a property and you want to convert it into an HMO that's under 6 individuals, you don't require planning permission. So you don't need to do the drawings and you don't need to apply for permission. If you then remove that, you are requiring that they put in a planning application and they need all the drawings. So that's where I refer to the architect's drawings that they could apply for.
Jeanette?
We've got 6 for 2025, but I can't confirm whether they were new applications or renewals. We don't keep a record of that on the public register, and they do have to be renewed every 5 years.
Okay, thank you. Okay. Councillor Jones.
Just like to go back to the independent person's question on whether the council's processes are robust enough Could you tell me over the course of, I don't know, the last 10 years perhaps, how often has the officers been called to investigate any problems within the licensed HMOs in the borough?
Jeanette?
I haven't got the exact figures to hand. We do only keep that kind of information for 6 years. We can look the figures up, but there haven't been very many at all. It hasn't sort of flagged up that we have any particular issues with HMOs at all.
Thank you. Could I just follow that, please?
You
Chair?
may, yes.
Thank you. So, if you've not had occasions, does that mean that the officers don't just routinely go and check on the condition and standard of the HMOs that are registered, that are licensed?
Jeanette?
They're followed up, obviously, at the initial application and renewal. And if we get any complaints, either from neighbours or from the residents themselves, then we will go follow up at that stage. There isn't any particular requirement to do an intervening inspection, but we can if there are issues raised.
Could I just...
Thank you.
One more question, please. So does the Article 4 or the optional licence give the council the ability to probe the standard of smaller HMOs?
As far as the amenity standards are concerned, they apply regardless of the size of the HMO, and we would, with the smaller HMOs, because they don't require licensing, we wouldn't automatically inspect them. But again, if we were to get any complaints either from neighbours or residents, in the same way as any other privately rented property, we would visit and inspect, and we have quite strong enforcement powers for doing that. And the optional licensing doesn't change that. We can do that without the optional licensing if we get those complaints or concerns raised.
Stephen Garner?
And insofar as the Article 4 direction is concerned, it doesn't give us any additional powers to go in and, under planning law, go in and do any inspections or check the standards either, similar to Jeanette.
Thank you. Thank you. Councillor Edwards?
This was a rather late interjection, but the reason I believe that we're all sitting here tonight, is there is a trend towards more HMOs due to the housing pressures, but we, as certainly in Fundersley South, have had specific concerns raised about the emergence of HMO property in one small close, and so we're responding to residents' concerns. It's not the only ward in the borough where people have been raising this. And I think, knowing what's going on is one of the key residents' concerns. But, the point that, people have a right to privacy in their own home and the right to be treated equally is very important for us to bear in mind as we're doing this. And you can't make assumptions about what sort of people are coming into HMOs. There's not a sort of people, they're people. So I think we need to tread carefully and get a balance in the decision we make tonight.
I totally agree. Independent person Dale Phillipson, please.
Thank you, Chair. Just mindful of the complex range of legislation and regulations and thresholds and requirements that we've been discussing, and the probability that responsibility for HMOs sits possibly across different teams and departments. I'm just wondering how information intelligence on HMOs, given all the things that we've discussed, how is that coordinated internally so that there's an oversight of this particular theme?
Damien?
For you, Chair, if I can start off with the answer. There are some agencies that will contact us about HMO use, and where that happens through a community safety department that sits within partnerships, I will then reach out to other assistant directors across the service areas and ask what's known about properties, do research on the properties, and make sure that we're all cited and we all have overall knowledge of what's coming our way, so that we can then take appropriate action or just be mindful of what could potentially be there in the background. In terms of notification of build conversions and licensing, obviously that goes through different channels, and that happens in a different, if you like, an application way before the HMO even becomes a HMO. So I'll pass across for those answers.
Stephen?
Insofar as sort of like the information sharing goes, the areas of the council that these areas of legislation fall under Jeanette, myself and Damien. We're all sit under Ian, under place and communities, and we have regular meetings to discuss. If issues were raised, there's the ability to work across departments, share information. To date, aside from preparing the information before you in this report, we've not had cause to do that, but that's the sort of arrangement that would take place.
Councillor Cortez.
Thank you, Chair. Two-part question. I personally believe there's quite a few unofficial HMOs that are operating in the borough. Should any of those come to light and be whistleblown so that they then do go for a licence, are there previous actions held against them as part one? And secondly, with regards to finances, obviously we charge a fee for applying for the licence. Is that as high as we can make it? Because if they're bringing it in, we may as well, the landlord's doing it to earn money, so the council may as well earn money from it. And do we charge an additional council tax? Because if you've got 6 people or 5 people living as separate people in a house, they're going to create, for example, more rubbish than a single family would. Thank you.
With the licence fee, I'm not 100% certain that one, I don't think that one is statutorily set. I think we set that as a council. But with all fees and charges, we have to prove that it's basically covering our costs. We're not able to make a profit out of those types of charges. And with regard to the council tax, I would have to defer to someone else for that, I'm afraid. Thank you.
Stephen?
I know there is council tax information on it, but I'm not sure what the specific arrangements are with HMOs and council tax. But what you say does make sense to me logically, but I don't know the answer.
With regard to previous actions held against them, generally we take a sort of a common sense approach. We would rather than have, as you've said, unofficial HMOs operating, we would rather work with the people that are managing them to get them properly licensed and their licence fee paid, and make sure that the amenity standards are met and that the people that are living in that accommodation are living in sort of safe surroundings that meet the amenity standards. So generally, no, we wouldn't take retrospective action. But obviously, if we do discover them and they don't go down the route of licensing, then we would start, and don't cooperate, then we would start to look at taking enforcement action.
Councillor Ainsley.
Call me off guard then. Thank you. I was going to ask about council tax myself. The question I was going to ask, is it on the property or is it on the inhabitants, the occupants? But that aside, I'm concerned about how often we're inspecting these properties. If we're only actually inspecting them once planning permission has been sought and the property has been converted, what's to say that once they've been given the green light that they're not going to change things? Councils have the statutory powers under the Housing Act 2004 to inspect HMOs for safety and overcrowding using the Housing Health and Safety Rating System. So I appreciate that resources are short, but shouldn't we be making sure that these HMOs at least have an annual visit?
Ian?
Thank you, Chair. Can I just come back on the council tax point, if that's okay? I'll leave it for others to answer that question. So in December, the 1st of December 2023, the Council Tax Chargeable Dwellings and Liabilities for Owners Amendment England Regulations 2023 came into force, and those regulations changed the way which council tax is calculated for a house of multiple occupancy. Prior to the regulations, the HMO could be split into single units by a local authority for the purposes of calculating council tax through a process called disaggregation. As a result, each separate room in the HMO would be liable for paying council tax. The regulations made two key changes. Firstly, HMOs are considered as a single dwelling for the purposes of council tax. And secondly, it's the owner of the HMO, not the residents, responsible for paying the council tax. Obviously, the valuation office, when carrying out valuation on the property, will obviously acknowledge the fact that it is an HMO, and that may then affect which band they're in. But that's what I've been able to find. But again, when we do the note on the compensation, we'll confirm that for you. Thank you.
Jeanette?
With regard to the annual inspections, yes, we could inspect them annually, but in the same way, we have a lot of private rented properties which also have to meet certain criteria to be rented out. Should we also be inspecting those annually, it would be a massive task. And I don't know that we've had any specific problems to suggest that HMOs need inspecting more often. They are done at the renewal time of the licence as well.
Yes.
What happens if it changes hands?
Jeanette?
They have to apply for because the licence is in the person who's managing it, the owner's name, they would have to reapply for the licence, and it would also likely be inspected at that stage as well because it would be a reapplication.
Thank you. Thank you. Councillor Edwards.
So thank you for the information, Ian. If I can just confirm that council tax valuation can be reassessed when a HMO is identified, which helps address the fact that the government has made that decision. But again, that relies entirely on us having visibility of the HMOs. Thank you. That's my theme for the night.
Is there any further questions? Councillor Cortez.
Sorry to be a pest. Point 4.7. It says that the council is permitted to consult with people of a relevant legal or financial interest, e.g. via a charge on the property. Now, the most common charge on a property is mortgage. Do we then consult with the mortgage lenders? Just a question.
To be perfectly honest, I'm not entirely certain. When they complete the application form, any information that's declared on there, if there is a mortgage on the property, I don't know what checks I can find out and report back to the committee, so my apologies for that.
Do we have any further questions? Councillor Ainsley.
Coming back to compensation, perhaps they might go for loss of earnings if they're delayed, consequential loss if they're delayed in letting the property out.
Through you, Chair, that's possible as well. They may also, something that I've thought of, they may also go for the costs if the application's refused at appeal, because before what they could have done under permitted development without planning permission if it's refused, and if they go through the appeal and find that they can't do it, you've removed that from them, so they may also apply for costs, which I don't know what those could tot up to, but it could be covering some of the cost of purchasing the property, for instance.
Councillor Edwards.
So, looking ahead to trying to formulate a recommendation to Cabinet, can we have some advice from Democratic Services just to advise us on if we were to potentially make a split decision, when are we able to revisit a decision? Or, I mean, technically the decision would be Cabinet anyway, wouldn't it? So.
Whatever you wanted to determine this evening would have to form the basis of a recommendation into a cabinet meeting. But obviously it'd have to be something that's sort of doable. Yeah.
Come back on that. I'm looking for how rapidly are we able to revisit it, either should the evidence change or just on a programmed basis.
Task and finish, isn't it?
Yeah, I mean, you could have a task and finish group to look at it if you if you so wished, Councillor Edwards.
Sorry.
Obviously, as the Overview and Scrutiny Committee, you've also got a work plan that that can be flexible, and that might be another route for you if you did want to do further work on it.
Thank you.
Councillor Thomas.
Thank you, Chair. Just going on from Councillor Edwards. We may well be able to conclude tonight anyway, depending on how we vote. I can give my personal view now, even though I did ask a question about financial implications. My personal view would be to implement it, or recommend to implement it, in 12 months' time. That would be my personal view. If we can come to an agreement as a majority tonight, we can move it forward, but it's up to the Chair to call the vote now. Thank you.
Just sort of looking at schedule of meetings, the director's just looked up. The committee has got a meeting on the 21st of October. So, in theory, it should be possible to to supply additional information between now and then, if the committee so wished.
Thank you. Thank you. Members, it is clear that further discussions are required on this. I will therefore move a recommendation that a task and finish group be set up to engage with members and officers to consider the HMOs, identify potential issues supported by evidence and the methods of potential control. Do I have a seconder? Sorry. Councillor Ainsley, thank you very much.
I'll second that.
Councillor Ainsley, seconded. Thank you. If there are any addendums...
Oh, no, don't worry.
That's all right, okay.
Is it agreed?
Chair.
Is that agreed, members? Councillor Edwards.
Can I just ask what the impact on timeline is of having a task and finish group versus just having the information and coming back to the meeting that you mentioned just now?
I think it's personally important for a task and finish group because HMOs is a big issue in the borough. We could hopefully get one done quickly. I know it's extra work for you all, or us all, but if we're in agreement, we'll push to get it done quickly and get an answer quickly and recommendations.
Thank you.
Councillor Cortez.
Sorry, I don't get what we need the task and finish group for. We're not writing a policy. All we're being asked to say is, do we want to go for the additional? We can't write an HMO policy. We're governed by legislation. It's saying, do we want to go for the additional requirement of planning needing to be granted if it's 3 rooms or more, and do we want to do the Article 4? That's all our recommendation. I can't see what a task and finish group's going to on such a small question.
Sorry, it was purely on recommendations. That's basically it.
members, you've got
Yeah. Yeah.
Thank you, Chair. So, yeah, I thought tonight's meeting was quite clear on what we were going to recommend to Cabinet should we come to an agreement in here amongst ourselves, which would be, would we recommend it being a voluntary sign-up, an immediate Section 4, or a 12-month Section 4? Apart from myself, no councillor has expressed an opinion which way they would prefer it to proceed, should it proceed tonight. I don't think we need a task and finish group, it just delays it. If we're setting our minds what the majority would recommend to the council, should we at least not ask every member how they feel, how they want to proceed?
Thank you, Councillor Thomas. I thought that's what we were doing with all the questions. My recommendation was going to be voted on, so you have got a chance to say yes or no. Sorry?
For it.
So the recommendation for a task and finish group, for those any for it, sorry.
Put your hands up.
Can you put your, sorry, forgive me. Can you please put your hands up and vote for it? No, we have no. And those against?
Okay.
Unanimous. Councillor Ainsley.
Yeah, I'm sorry. There's a bit of confusion here from what I understand to what Councillor Thomas understands. That what we're suggesting. What I'm suggesting is, and I think what you're suggesting is we've got unanswered questions that we'd like to investigate further before we make a final decision.
Yeah.
I mean, I think the task and finish group title is probably over the top. It's not exactly what we wanted. I just think another meeting just to get the information that we've requested. Yeah, to clarify, yeah.
Right, I'm going to hand you over to Sonia now, as that is the request.
Can I suggest, as I think I've already previously mentioned, there's been a lot of additional information requests this evening. Can officers pull that together, and then it comes back to the next meeting of the committee on the 21st of October? Yeah.
Are we all in agreement with that? Agreed. Thank you. You did get there in the end. Right. Right, where am I up to? Yeah. Right. You've all confused me now. Right. Agenda item 6, the work plan. Members, the updated work plan has been circulated. Are there any further suggestions? Which that is agreed. Is that agreed, members? Councillor Cortez.
I'm sorry for being a pain. Last meeting, I asked about the splash park on Canvey. Obviously, Angela was the one that responded and said it was going to the asset review board. It was just a follow up on that. Did we have an update? I know you can't answer it because she's not here, but could we have an answer for the next meeting, please?
Yes, please. Can we make a note of that, please? Questions? No. Yeah. And thank you. That concludes the business for this evening. Thank you for your attendance. Thank you to our independent persons for travelling and being with us and joining us tonight. We do appreciate that. Meeting closed at 20:24.